Well, hello, everybody, and welcome back to Buckle Up. It's the law. Folks, what a day we have had. What a day we are having. I mean, it's unbelievable. Unbelievable. Trooper Proctor finally, after not one, not two, but three hearings with the disciplinary board, finally gets let go from the department. He had a hearing in January, he had another hearing in February, and now a hearing in March just last week on Friday. And today, Wednesday, March 19th, he is officially let go, released, fired, whatever you want to call it, from the department. And he is no longer going to be a Massachusetts State Police trooper. Now, he was already on paid leave, unpaid leave, I don't recall which, but he was on leave. I remember he was on leave. And so he will not be able to testify without having to account for the fact that he's no longer with the department. Now, if you remember from trial number one, he was also wearing a suit and tie. I think Lally knew that some of these troopers are going to be dropping like flies, and in anticipation, he told every single law enforcement officer on the case, detective, trooper, whoever, whatever, ATF agent, Brian Higgins, whose series we're doing on the channel, by the way, um, don't wear a uniform, he said. Do not wear a uniform. Just wear your suit and tie and forget about everything else. Because he knew some of them are just going to be gone by the time things get around to it. And he was afraid he might start losing witnesses in the middle of trial. And if you have 10 troopers appearing in uniform and then a couple without a uniform, that raises eyebrows. The jury's going to be asking questions like, why are these officers are in uniform and these are not? So if you just make like a blanket rule, everyone's going to be not wearing a uniform, just wear your suit and tie, everything is going to be fine. Now, having said that, the trial is still going to move forward. And I will get to the juicy stuff that I have for you all in just a moment. I have some filings that I obtained from the Norfolk County Courthouse that I don't think are in possession of Ted Daniel. Usually Ted Daniel and that Rex lady, whatever her name is, I just can't remember it because I don't like her. I like Ted. Ted's cool. Um, Usually they have first dibs, but somehow I was able to get it directly from the courthouse, and I'm excited to share it with you all here today. So, what is happening? Other than the amazing, great news that everyone and their mother are talking about right now as we speak about the firing of Trooper Proctor and how it's going to affect the case, I'm going to let them do that for a while I share the following with you. So, Karen Reed filed a motion to continue the trial. This was filed late last night and accepted by the court this morning. So this is brand new stuff. This just happened minutes ago. Defendants assented to motion to continue the trial to a date on or after April 15th, April 25th, 2025. Let's go over it together. Now comes the defendant, Karen Reed, and I hope you all can see that okay. Now comes the defendant, Karen Reed, by and through undersigned counsel, and hereby moves this honorable court to continue the trial in this matter, currently scheduled for April 1st, 2025, to Monday, April 28th, 2025, with a final pretrial conference on Friday the 25th. So it's a simple request, okay? She's asking to have the trial date moved from the original starting date, which is April Fool's Day, although as much as we love for this to be, as I tweeted, the biggest joke of 2025 is the retrial of an innocent woman is unbelievable. We're in two verdicts. We have two not guilty verdicts, and Bev refuses to acknowledge their existence. Unprecedented stuff. She's merely asking for a 3.5-week continuance. Really not a big ask. But why? Let's get into it. The defense respectfully submits that such continuance to which the Commonwealth assents, as further noted below. What does that mean? The Commonwealth assents? He didn't say the Commonwealth agreed to it. The Commonwealth assents. We'll find out in just a moment. To which the Commonwealth assents, as further noted below, is necessary to permit Ms. Reed to appeal the denial of her federal double jeopardy claims, which the federal district court expressly found to be substantial, quote unquote, to the First Circuit Court of Appeals prior to being forced to undergo a retrial that Ms. Reed contends would violate her rights. So I just realized I didn't bring my water. Okay, I'll be a little thirsty. That's okay. So what is happening? We have the appeal of Karen Reed's decision, and I'm about to break it down even further as it is stated in the motion. Karen Reed has appealed the judge's decision to just keep things moving as is. And now, since the appeal is still not concluded, you see, Bev wants to start her trial because it's her courtroom and it's her docket. But she has judges above her who have control over her. She does have bosses. They're not her direct bosses. They're not going to show up at her office and supervise what she had for lunch and why she took such a long break, for spring break or anything like that. But if she makes rulings and decisions that contradict the rule of law, the Constitution, statutes, facts, etc., well, then they can come in and say, no, and reverse her. So that's what Karen Reed has been asking from the higher courts. So let's break it down. As we all know, on June 9th, 2022, Ms. Reed was charged in 3 separate indictments with second-degree murder in violation of the murder statute, manslaughter while operating under the influence of alcohol in violation of that statute, and leaving the scene of an accident resulting in death in violation of the other statute. A jury trial began on April 16th, and this court declared a mistrial on July 1st, 2024. Now, after the mistrial, let me make this a little bigger. Crap. There we go. After the mistrial, Ms. Reed moved to dismiss counts 1 and 3 on double jeopardy grounds because the jury has acquiesced. There's affidavits in the record stating that we voted unanimously not guilty on counts 1 and 3. On August 22nd, 2024, last year, after hearing oral argument, this court issued an order denying Reed's motion to dismiss. On September 11th, Ms. Reed filed a petition for relief with the Supreme Judicial Court, SJC, pursuant to another rule. On September 19th, a single justice of the SJC, Dewar, reserved and reported the case without decision to the full court. On February 11th, the SJC issued an opinion affirming the denial of Reed's motion to dismiss. So this is fresh, It's not Alan Jackson's fault. It's not David Yannetti's fault. It's not Liza Little's fault. It's not, I still don't know his first name, Alessi's fault. The fact that the SJC took nearly 6 months to issue a ruling now puts the new trial in jeopardy. Because let's say, hypothetically speaking, Auntie Bev does start the jury trial on April 1st, and we do get a favorable ruling on June 1st. Bev will have just wasted 60 days of the court's time on a trial that should have never happened in the first place. Because if there's a favorable ruling, what do I mean by that? That means we need a new jury, and we have to start everything over because if the higher courts ruled that charges 1 and 3 shall be dismissed pursuant to double jeopardy grounds because a jury has already ruled on it, even though the judge never asked, that's a problem. And the prosecution can now only move forward on charge 2. And they can't just in the middle of trial be like, oh, by the way, ladies and gentlemen of the jury, forget everything that we did and we're going to start over. Okay? It's like, what's his name from Office Space? I'm going to need you to bring this down to just 1 count instead of 3 counts. Okay. Yeah, that would be great. You can't do that. You would have to start the proceedings over, and that is not how things are done. So, in order to avoid this mass confusion and uh, massive waste of the court's time and the people's time and the jurors' time, there's a very simple solution to all of this: get a new trial date. Okay? That's what Alan Jackson and the team are asking for. Ms. Reed filed her federal petition for habeas corpus on February 18th. After oral argument on March 13th, the federal district court denied the petition. So that is even more recent. This is literally Friday on Proctor's last hearing on the same day. Before denying the petition on the merits, the district court found that one, Ms. Reed properly brought her petition under 28 U.S.C. 2241, and this is very important because if there were certain elements that were not met, well then there may not be a valid appeal in the first place. So this is extremely important because sometimes courts of appeal are very, very, very strict. We have appealed several cases, and I know firsthand, you God forbid you miss one deadline. Don't do that. Because if you miss deadlines, the court, even if your case has merit, the court may just dismiss it outright. So this is extremely important that her petition was brought properly. She satisfied the custody requirement to bring a habeas petition. Number two. Number three, she exhausted her state court remedies. And number four, no abstention doctrine barred the federal court from considering the petition. The district court granted a certificate of appealability, finding that Ms. Reed made a substantial showing of the denial of constitutional rights as to all claims. Ms. Reed filed a notice of appeal the same day that the district court denied her petition. So this is ongoing. This is fresh stuff. This is literally happening. It's like catching a live grenade, essentially, the equivalent thereof. And pursuant to an expedited briefing schedule agreed upon by the parties, Ms. Reed filed her opening brief on March 18th, 2025. The appeal will be fully briefed by March 26th, just 4 business days before her scheduled retrial. So there is a big fat 0% chance that the court is going to issue a ruling. They do not issue rulings that quickly. Now, the fact that the appeal is going to be fully briefed that fast is, I have never seen anything like this. An appeal from basically start to finish in the higher court to be briefed basically within 2 weeks is unprecedented. But they're doing it because of Auntie Bev's strict deadline of wanting to start the trial on April 1st. They're actually showing to the court that they are respecting its time and they are moving things along. They're not getting like May deadlines or June deadlines asking Auntie Bev to continue this case to like fall or the end of summer. So this shows the judge in the Karen Reed case that, okay, you guys respect my time. I don't know if it's going to play a factor. She's probably going to deny this request, but we don't know. So what does that mean? Remember we talked about the Commonwealth, what was the word that was used? Assents, I believe. That the Commonwealth assents to this. Why do they assent to it? I think that's this language right here. The appeal will be fully briefed by March 26th. So that means the other party is also going to respond. And who's the other party? Norfolk Commonwealth Attorney's Office, of course. So by virtue of them agreeing to brief this as quickly as possible, they are kind of acquiescing. They are acquiescing to the defenses and the prosecution's essentially desire to we need to resolve this. So even though they don't have an agreed order, see, the easiest thing in the world to do, and you will never get this from Brennan or Lally in a case like this. But for Jackson or Yannetti or Little or Alessi to go, listen, can we do an agreed order? An agreed order. Now, a judge can still deny, even an agreed order. An agreed order simply means the defense and the prosecution both agree. Hey, we want to do this, judge. We both want to continue the jury trial date to Monday, April 28th. That's okay with you. We cool? And then the judge is like, well, Brennan, you agree? Yes. Jackson, you agree? Yes. Okay, cool. But they don't have that because Brennan will never agree to this. So he wants the trial moving. He doesn't care. He doesn't care about Karen Reed's rights, and he doesn't give a damn about what happens in her federal appeal. He is just preparing for trial. As the United States Supreme Court has observed, the rights conferred on a criminal accused by the Double Jeopardy Clause would be significantly undermined if appellate review of double jeopardy claims were postponed until after conviction and sentence. It is a guarantee against being twice put on trial for the same offense. Let me read that again. And I'm going to try and use human language rather than court lingo. As the United States Supreme Court has observed, the rights that Karen Reed has given to her by the Constitution, specifically the Double Jeopardy Clause, is significantly going to be hindered if we don't give the courts of appeals an opportunity to review until after she's convicted and sentenced. So imagine the trial proceeds and Karen gets convicted, God forbid, and sentenced to prison. What would happen then if the appellate courts go, wait a second, no, we're overturning counts 1 and 3, you got to start over. Because then the judge can't go, well, they convicted on charge 2 as well, so no harm, no foul. We'll just dismiss, her sentence. We'll vacate the sentence on charges 1 and 3, and we'll just keep number 2. That's not how it works, Bev. You would have to start over completely from the beginning and do a retrial on charge number 2. So it's a giant mess. It's a giant cluster when it comes to these appeals because now you have two courts kind of fighting and they're both dealing with the same case. Obviously, these aspects of the the last sentence I forgot to translate to human language. I think it's fairly straightforward. It is a guarantee against being tried twice for the same offense. Same thing. Obviously, these aspects of the guarantee's protections would be lost if the accused were forced to run the gauntlet a second time before an appeal could be taken, even if the accused is acquitted, or if convicted, has her conviction ultimately reversed on double jeopardy grounds. She has still been forced to endure a trial that the Double Jeopardy Clause was designed to prohibit. Basically, there is absolutely no reason to have her tried again on this stuff. And while there is something pending upstairs in the higher courts, let's put a pause to this. Let's continue the trial. Give us a little bit more time. Give the courts a little bit more time. Today is the 19th. The case will be fully briefed next week by the 26th, which is next Wednesday. And that is a reasonable request, in my opinion. Now, before I continue reading, I just had a thought. Here's a possible scenario. Actually, you know what? Let me finish reading first. Ms. Reed respectfully submits, so this is the conclusion. The double jeopardy protections at stake in this matter are simply too important to force her to stand trial for murder, in what she contends would be a violation of her rights, before having the opportunity to appeal her substantial constitutional claims. Obvious. Moreover, whether Ms. Reed's retrial will proceed on all 3 counts or be limited to count 2 will materially impact her trial counsel's strategy and decision-making, such as opening statements. I mean, right out of the gate. Is Lally going to say she has 3 counts and then by the end of the trial, never mind, it was actually 1 count? Um, or be limited to count 2, which will materially impact counsel's strategy and decision making, such that the such that the defense believes Ms. Reed is entitled to know which counts she will be tried on in advance. That is not unreasonable. That is a very natural. How can you prepare for something you don't know what's going to happen in the future? The Commonwealth assents to a short continuance of the trial to the end of April 2025. So maybe they do have some sort of agreement. I don't know. I'm kind of trying to read into it, but I don't know why they don't just submit an agreed order to continue. Maybe Massachusetts does things a little bit differently. Kentucky, if I call the prosecutor up and I say, hey, listen, I can't make it on Wednesday. Can you do you mind like agreeing on a new date? Yeah, sure, no problem. What date do you want? Hey, can we do April 28th? Yeah, no problem. Hey, I'll draft an agreed order, send it to you. You review it, and then I'll submit it to the judge. Cool, no problem. We submit it to the judge. We both sign it, submit it to the judge, and the judge is like, okay, you guys both agree? All right, no problem. Continued. Like that's normal in practice. If you have to ask the judge every single time for anything and everything, it gets daunting and annoying, and there's no camaraderie between you and the prosecutor. It's okay to maintain the peace while still aggressively representing your clients. You don't have to be a douche about it. So the assent is without prejudice, and the Commonwealth expressly reserves the right to oppose any further continuance or delay of the trial, including if the First Circuit appeal has not been resolved by the time of the new trial date. So they could at some point also object if they're like, okay, this is taking too long, and then the court will decide. But for the foregoing reasons, Ms. Reed respectfully requests that this honorable court continue the trial in this matter to April 28, 2025, or the first available date thereafter. Now, two things. Number one, I have one more surprise for you, which we'll get to in a moment. Number two, I want to finish talking about this. And we're going to do this in reverse order. So number two first. There is a world of possibility where the following sequence of events could happen. And I've had this happen in my own cases. Or no, maybe not exactly this, but something similar. Something very, very similar. And the more I think about it, I'm like, I didn't have exactly this. Basically, here's what could happen, okay? Here's what could happen. Number one, this motion is filed. It's officially entered by the court this morning, this afternoon, and the prosecution may or may not respond to it, and Auntie Bev is going to have to rule on it. If Auntie Bev denies the request, if she grants it, that's it. New trial date, April 28th, no problems. If she denies it, I can tell you from experience and other people's cases for sure, the team, Alan Jackson and Yannetti and Little and Alessi, they can all go to the First Circuit and go, Your Honors, we have a problem. And they're going to go, what's your problem? We have exhausted our attempts to try and get a continuance. As Your Honors know, this brief is due, today, tomorrow, yesterday, whatever the date's going to be. The lower court has refused to continue the trial date. We are without any other option. We are asking you to intervene. I tweeted about this a couple days ago, I think. Or maybe it was earlier today. I'm losing track. There's so much happening. And stay proceedings. Freeze Auntie Bev's actions. Freeze her hands. I had this in a motion to recuse case where a judge just kept trying to continue proceedings. I said, Your Honor, you are stripped of jurisdiction. It is my most viewed short on my channel. It has 20, 30 million views. I don't know. It's literally 1/10 of the views of my entire channel or something like that. It's insane because it was a very intense moment. I had an unruly judge who refused to respect the rule of law, or maybe she didn't understand it, or maybe she thought I don't know. But the law was explicit. The law simply stated, hey, you do not have a right to continue proceedings in this courtroom until the higher court either denies my motion to recuse or grants it. If it denies it, well, then we keep going unabated. If it grants it, well, then you're going to have to recuse yourself and replace yourself with another judge. And then COVID happened. And none of that ever like came to fruition, and the jury trial got pushed, and I got sick. It was a bunch of stuff also happening in 2020. So I can speak from experience. And there are rules, there are laws that state that in certain circumstances, not all of them, certain circumstances, if there is a higher ruling pending that you're waiting on from a higher court, the lower court must respect it and step aside. In my case, because it was a motion to recuse, the judge just said, okay, we're just going to show up every day, like Monday, Tuesday, Wednesday, Thursday, Friday, Monday, Tuesday, Wednesday, Thursday, every day until we get a ruling. And I'm like, Your Honor, you can't hold us hostage just because you are here. Now I have to subpoena all my witnesses. The prosecutor has to subpoena his witnesses every day to come to court at 9 a.m. That is completely unreasonable. And so we ended up butting heads, but like I said, it all worked out, and we ended up winning the jury trial a couple of years later. That's all on my YouTube channel. It's the guy who who ran his car into a house. A very, very crazy case. But anyway, back to this case. If Auntie Bev becomes unruly and says, nope, no continuances, don't care about your appeal, go screw yourself, Jackson, Yannetti, Alessi, Little, I don't give a damn about your appeal, I'm moving my courtroom unabated, well then they can go to the higher court and they can say, listen, Your Honors, the lower court will not listen. We've tried everything. We tried getting them to help us, get this thing moving, and we're not going to have a ruling over the next few days, and trial starts on what's April 1st? I think it's like a Wednesday, Tuesday. Trial starts Tuesday, and today is the day before, 2 days before, 3 days before, business-wise. We ask the court to issue a ruling to stay proceedings, freeze proceedings in the lower court, and the court can do that. The higher court has absolute power to literally look at Auntie Bev and say, pause. You're not done. Just hit the pause button. It's not stop. Hit pause. And she will have to hit pause. She can't override a higher court because she is in the lowest level. Well, I guess one level below her would be district, where they deal with petty misdemeanors such as theft, lower level assaults, stuff like that. So Auntie Bev has limited jurisdiction in this regard. So if the higher court says stop, she has to stop. So if Yannetti, let's say, goes to the higher court right now, the higher court can say, no, have you tried talking to the judge? No, Your Honor. Well, do that first. Oh, okay. Well, it would have been exhausted, okay? So that's that. Now we have another document that we're going to go over. This is the defense's witness list. That's right, folks. We have Karen Reed's witness list. Let's check it out. These are all the witnesses that Alan Jackson and David Yannetti and the rest of the team plan on calling during the trial. And some of these names might surprise you. Brian Albert, Caitlin Albert, Christopher Albert, Chris Albert, Colin Albert, Julie Albert, Kevin Albert, Nicole Albert, those are obvious. They're all going to be prosecution witnesses. Michael Wagner, Cheryl Woe, Paul Makowski, Leslie Bernstein, Rebecca, I'm going to butcher some of these names. Rebecca Bison. Officer Nicholas Barros. So because he is removed from the witness list for the prosecution because he had such favorable, great things to say and he can be cross-examined, and you can probably treat him like a hostile witness because he is an officer. He's not a friendly witness. Trooper Evan Brent, Buchanan, Lori Cahill, Trooper Zachary Clark, Christopher Curran, Kerry Curran, Nicholas Curran, Richard D'Antuono, remember him? He was a fun witness. Officer Kelly Dever, Stephanie Devlin, Trooper David DeChico, Patrick Haggerty, Maureen Hartnett, Brian Albert Jr., and of course, Brian Higgins. The series that we are doing right now. Excuse me. Louis Jutras, Trooper Connor Keefe, Matt Kelly, Karina and Nicholas Kalakathis, Terry Kuhn, Sergeant Michael Lank, of course, Brian Loughran, Heather Maxon, Allie McCabe. You ain't going nowheres. We want you back. We want you to slip up again. Jennifer McCabe, Matt McCabe, obviously. Lance Mello, Ryan Nagel. He had a lot of interesting information to say about the Jeep, if you remember, and the location of Brian Higgins' Jeep, because this is the phantom Jeep that just appears and reappears whenever it damn well pleases. Steve Nelson, Andre Porto, Holly Price, Trooper Kathleen Prince, Elizabeth Proctor, Trooper Michael Proctor, come on down. You ain't going nowheres, buddy. Carrie Roberts, Wendell Robbery, Stephen Ridge, Heriberto Hernandez, Mark Lopilato, and Alfredo Lopilato, Angela Malvone, Lieutenant Brian Tully, Courtney Proctor, Trooper Proctor's wife is on the defense witness list. They might call her to the stand. Now that would be a day. Oh my God. Tristan Morris, Jean Demoulis, Mary Souza, Ashley Bell, Mike Rushworth, Matthew Emery, and this is probably the biggest surprise of this entire list, for me at least. I don't know if he was listed in the last trial, but Norfolk County District Attorney Michael frickin' Morrissey is listed as a potential witness who might be subpoenaed to testify on behalf of the defense in trial number 2 of Karen Reed. This is unprecedented, folks. Or Courtney is his sister. I'm sorry. I thought it was the wife. Elizabeth Proctor. Elizabeth Proctor is the wife. I don't think we saw Elizabeth Proctor's name. I apologize. I'm doing this live, by the way, so it may have some errors, and I do apologize in advance. Thomas Beatty, Aaron Beatty, but Michael Morrissey? That is crazy. Megan Mariani, Thomas Martin, John O'Keefe Sr., Lieutenant John Fanning, the jury diddler, and I don't mean he diddled the jurors, I mean he messed with the jurors, not sexually. Matthew Kelch, Thomas Kelleher, Annie Chung, Helena Rafferty, Irene Scortibello, Trooper Jeffrey Kostkowski, Trooper Paul. He's also on my list of to-do crosses on my channel, so be on the lookout for that. Sergeant Paul Di Giampietro, Sergeant Paul Gallagher, Chris Van E, Dr. Chris Van E, we remember him from the first trial, Richard Green, Daniel Wolf, Dr. Daniel Wolf, Dr. Andrew Rentschler, all of these are from the first trial, Maggie Gaffney, Derek Ellington, Michael Easter, Matthew Erickson, Matthew DeSagra, Elizabeth Laposta, Dr. Mary Russell, and Garrett Wing. And this was all submitted late last night, and like I said, accepted by the court this morning. I think the stamp even says when. 8:10 in the morning is when they accepted the filing officially by the court. Phew! Man, what a lineup. I mean, if the first trial took 9 weeks, it started April 15th, including jury selection. It was all of May, all of June, and half of April. That was 2.5 months. With this lineup, and plus we're going to have to do all the prior inconsistent statements from the first trial. Oh, dear God. Because they're going to lie through their teeth. They're going to forget what they said. They're going to forget their lines. Can you imagine somebody sitting like, yes, I did. And then you didn't see any man enter the house. No, I did not. And then what about the dark figure that did go into the house? Line? Like actors. Like, what's my line? What do I say to that? I don't know how to answer that question. We didn't prepare for that. Or what did I say in the first trial? I don't remember what I said in the first trial. May I review my testimony? I don't remember what I said. You're going to hear that answer a lot. I don't remember what I said in the first trial. Do you mind giving me a copy of what I said in the first trial? And of course, I'm gonna be like, no, you're not going to get diddly squat, buddy. You need to testify from memory, because if you need to review anything from previous trials, that means you are lying. You were lying then, and you just forgot what you said. You forgot what you lied about, because you don't need information that is the truth. If it's the truth, then you know it. You're going to have images of it in your head. If it's fabricated, you can forget it. But if you have images in your head, you never forget that. So it's going to be interesting. It's going to be interesting. When Jennifer McCabe and her if you haven't seen that series, by God, go check it out. It's on my channel. But anyway, that's all I have for you folks. I wanted to keep this nice, short, and sweet, just under 40 minutes, it looks like, to cover some new stuff that has recently been submitted to the court. April 1st might not actually be our trial date, after all. We may get a continuance, and until then, peace and love to all of you. I love you guys. Thank you all for coming. I hope you learned something. I hope you were entertained, educated, and follow me on X, where I tweet a lot of this stuff, especially the Proctor stuff. Oh my God, the Proctor stuff. I told you something big was coming. I told you guys, and it's not done. Larry Foreman is not done. Larry Foreman has more cooking. The chef is cooking. The chef is cooking. I have a video that will probably, I was hoping to release it tomorrow, by tomorrow I mean, but I might have to extend that request to Friday. So give me a little bit more time, but the cat is out of the bag. The cat is out of the bag, folks. So I know you don't like waiting, but unfortunately you're going to have to. So I do apologize in advance. Good things take time. Good things take time, okay? So until then, folks, I will see you in the next video. There is a Blake Lively analysis of the protective order that witch moved for, that was denied in part and granted in part by the court. Short and sweet video. Go check it out. And then part 6 of Higgins is going to premiere probably tomorrow. I might release it tonight, but I don't like to do 2 videos in one day because that puts pressure on me. So it will probably be released tomorrow. And there's a total of 11 parts. And then we're going to do Yuri Buchanan. And I have a lot more stuff in the hopper for you. I have a Beverly Cannoni video that I've recorded. I have another secret project that I'm working on. And that's going to be released in the next few days. And I also have another video that I'm going to be recording about Jeremy Hales and that saga. So lots of content coming your way, folks. And there's one video that I've been kind of lamenting to do. It's I'm going to title it like My Grandfather's Journey or something like that. As some of you who are regular followers of this channel know, that I lost my grandfather about 3 months ago. to cancer, prostate cancer specifically, and I was gonna make a video about him and his life and his journey, like all everything that I know, which is relatively little, unfortunately, because he was very private. He liked to share things, but it was always like disjointed. And eventually, I'll make a video celebrating his life because I want to memorialize it forever on my YouTube channel because he's my granddad and I love him very deeply. And it's just been really heavy. Anytime I'm like, I should do it, I just get depressed and I don't like being depressed. So eventually I will do it. Eventually I will make that video and we will move on from there. So again, I love you guys and I will see you all in the next video. Bye everybody.